So we're calling the meeting to order. Yeah, restart. Where will we start? I'm sorry.
We're calling the meeting to order.
That's perfect. And I've just had enough time to finish chewing the last bite of my meat stick. So I'll now
So the
introduce.
timing is good. And now we're going to do the demo of the realm board.
Yes. So what we've done here is create a PowerPoint of some pieces of the realm portal that we think might be interesting to you. Basically, kind of outward facing items. This is a little bit like an iceberg. You see the top, the way in which the public will interact with this database is like the tip of the iceberg, but what is underneath is significantly larger than what you see. But you will not interact with that behemoth for the most part. I will not interact with that behemoth for the most part. But those who are doing the real work of the agency do interact with that every day. It's the way in which we will receive payments and track payments. It's the way in which we will track the entire enforcement process. Same with the education process, the renewal process, the application process. All of that has significant behind the scenes that's really somewhat irrelevant to the external user and even to at kind of a high level. It is not all perfectly put together seamlessly today so that you can be like, here's what it looks like, click, 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 click. So what we've done is we've created a little bit of a image of what that will look like as it relates to some of the most interesting pieces. Fair?
That's perfect.
Good deal.
What we're not doing today is saying, I don't like this color, this font isn't good, that sort of thing. All of the pieces that will make it, what's the word I'm looking for? Aesthetically pleasing, have not been implemented yet. So we're still on like the nuts and bolts, if you will.
What, can I ask a question before we start? What are you expecting from us as it relates to this demonstration?
This is a bit of like a proof of life. Like, see, this exists, this is happening. And this is at the request of a commissioner months ago of, will we be able to see a demo? Yes, here it is.
And this has been talked about for what, 2 years, 3 years? I don't know.
Yeah.
Feels longer.
Nothing for you to do.
Just absorb.
That's correct.
And for the record, I'm Denise Sample, the Director of Licensing. And so Mike Malloy and I, the Director of Standards and Enforcement, we put this together to kind of just show an overview of what will be the first step as someone engages with the system, with the realm portal once we're live. So very first thing up, you've got to create an account. You have to create an account to apply. You have to create an account to renew your license, create an account to file a complaint. Possibly submit a public information request. That could be part of it. We're still working that out, but the first things first is create an online account. So there are 2 ways to do that on the page: create an account or register for an account. And so then on the next slide, and this just kind of walks through the screens for creating that account.
Do both those links go to the same place?
They go to the same place. Yeah.
It's
So
just
these are
different.
the kind of the things we're still, I know I shared this with Summer Mandel and she already had feedback. It's like, yeah, we're still trying to get the bulk of it kind of working, the data conversion, as Executive Director Buckholz mentioned this morning. And so these are kind of the final touches, and we're not there yet. But
So you want questions and comments as we go, or you want us to hold them back till the end?
whatever you prefer. We've had lunch, so if you don't want to hold off.
She's good at being interactive.
Yeah,
I'm
keep
already
everybody
on the
awake.
lead, so
Can you move forward as a guest, or do you have to have an account?
you have to have an account.
Okay.
Have to have an account. Not for the license holder search. That is going to be a public facing, separate from the system. This is to log into the system and do all the things with TREC and use your credit card. I hope y'all are out there getting that message.
James just asked,
Oh, yeah.
will accounts from the old system transfer to the new system?
No.
No. So there will be a campaign of, you need to create an account. Do this now.
Which goes in line with our messaging of, hey, you don't renew until December, but go ahead and do it now. So that way you've got a little more time after the launch of the system.
And that's when you get the business address as well.
Well, right, we're still, because that's new and takes effect January 1. We're working on
Okay,
the configuration of that piece, as well as the broker associate, and the link.
perfect, thanks.
So to create the online account, you've got to fill in the required fields. So this is Bob Johnson, security question, read and agree to the terms of service, and click continue. We know everyone's going to read every word of the terms of service. And then here is where you branch off on what kind of account is being created. Is this an applicant or an individual or an organization? And more required fields that are listed there. And so on the next slide, you get a confirmation. Your account has been successfully created. So then you are forced to log back in. So then you log in using the credentials you just created, the username or email. So we're hoping, Robert this morning was reporting on a lot of the calls are password resets. So the hope is that if there's a username that's registered as opposed to my email at this particular brokerage.com, when they move on and come back to the system 2 years later to renew, they can use that username and don't necessarily have to have access to the old email. So then that person signs in.
Will they have multiple emails? Can they have multiple emails in their account?
Not for the account registration. Not for the account registration.
List more than one.
You could, I believe that there is an ability to add additional contact information. We only want one, the email of record. And this is, I think for the account creation, I think that's pretty standard. I'm looking at Tom Watson. There's just one email address tied to an account. So now this is what the homepage looks like. So it's a little, it takes some getting used to, but you're on the homepage because that's the one that has turned red and has a little arrow below it. So as you click to licenses or to complaints, then those will turn red and the others will do also the CP blue. So if you click on my account or account management, again, another scenario where two different links take you to the same page. Go to the next slide. This is where you can click on, I have it back, I apologize. I'll go back. For when you click on licenses, that's how you'll get to the page to create an application. But on that dashboard, if you had an application that you'd started and you got distracted, you had to walk away, and you didn't submit it, that would appear down there in your working progress. So there's a way to save it and come back to it. It won't live there in a pending status forever. We do have responsibilities to clean up any records. So we're going to have a schedule. Those will get removed, but your work in progress is tracked there for a suitable amount of time. So go to the next slide. One back. Okay. No, that's okay. So then create an application is the link you click on, and then you'll go to the next one. And then, this language is still this is just default stored right here. So I would not pay that close attention to this language here. We're still waiting on approval for final language. But this is, letting you know general disclaimers. You agree and accept and click continue. And then you pick from a dropdown of what application you're trying to submit. So recall this is also for timeshares, for qualifying education providers, for TALCB's provider applications as well. So you'll select, in this example, we're doing a real estate sales agent application. So then you'll, no, you're fine. So you'll continue, and then once you get to this screen, now you have the option to save and resume later at any step of the process. So there are the following slides kind of show going through and adding additional contact information, which will include the new business contact info. There are questions that are required on every application. One unique feature I will point out with the Realm portal is in regards to the military applicants, because they've got certain benefits available to them if they meet certain qualifications, they don't have to pay a fee, and their application gets fast-tracked into its own queue behind the scenes. So we're going to start out with some military questions just to determine right out of the gate, are your fees being waived? And do you go into this special queue that is going to be monitored and handled with expeditiously? So if you continue on.
How is that validated?
I'm sorry?
How is that validated?
On the back end, so after all of these slides, it's an application is still going to come into a work queue for someone on my team to review. And at that point, they'll start going through that checklist and the process to validate, the military change orders or the ID and all of the other steps.
So they have to show you documentation that they're in the
There's certain documentation required, and that's all set by the statute and rules. And so this is just a way it's easier to waive the fee up front if we find out, oh, they don't actually meet the criteria. We can send an invoice. It's a much harder process to collect their fee in their application and then have to go back and refund it when we find out that they meet it. So that's the reason for that kind of design. And so now you can add, alternate names. Michael goes by Mike, etc. The education, this is where, I'm not sure how many of you are aware, but for the most part, yeah.
So they won't have to fill out this.
Not for the
What's
alternate
the
names.
question?
Will they have to fill out an assumed name form?
Oh,
And not for, the alternate names are the Kim for Kimberly, those types of, or, what is our example that we use a lot? Scooter. We had a license holder who was Scooter. That's the name that was used professionally, and there was no way you would gather from the legal name that that's that name.
is there oversight over this too?
No, it's similar to the name management tool today with the alternate names. Those are provided by the license holder. Moving on. So this is where an applicant would upload transcripts from their accredited college or university. And this is just a snapshot because we didn't go through the screens for uploading. There are things we're still working out, including the transferring of course completion information electronically. But this is where an applicant, this tab right here kind of tells you where you are in the process. So the application information is kind of going along and telling you what else is needed. So if you just continue through, supporting documentation can be uploaded, and that could be related to the military questions. So they have a chance to submit it with the application, or additional, if they answered yes to the question, do you hold a license in another state? This is where they could upload the license history for the other state. And then if you click next, and this is the review screen. And if we were to scroll through, you can see the answers to all of the questions that might have been asked and get a chance to review it before moving on to the next step of continue application. And then you're presented with the fees. And so there's no one beauty of the online application process is there's no room for error. They don't get, the applicant does not get to type in the dollar amount that they're submitting to us. The number of checks that we have to reject because they're written for the wrong amount is not insignificant. And so this is nice because it does break it down, but the total is the total. That is what we're collecting.
This will be a huge efficiency.
Does it ask if you're a citizen or a lawfully admitted alien?
I believe it's the same questions that currently exist on the online applications and on the paper forms. So all of those, just for the sake of this.
Okay.
So, yeah, all of those are being configured. And so this is your payment screen. This is already in the new payment processor. And so it immediately upon submitting the fee, you've entered an email address here. And then immediately upon submitting it, you'll get this screen that says, thank you, your application has been successfully submitted. And so now, at this point, my team on the back end can see that application. It's gone into one of our queues, whatever bucket we've directed it to go to, based on the application type. And then applicant can click here and immediately pull up the PDF receipt, or they can check their email and it'll come via email as well. So there's what the PDF receipt looks like. And then this is the email that comes out. And it's instantaneous. And so this record link is what allows the applicant to go back into the system and pull up. This number will match and will show up in that workflow as an application that they can go in and review. So, yes, so this is the page that you're taken to when you click on the link in the email. And then you can go to the record link and click on record info. And so there's a lot of information. You can see everything that was submitted, and more importantly, it's processing status. So the next slide expands on that screen. So you'll be able to see where it is in the process. Just for benefits, for the sake of this demo, we didn't have one that was kind of halfway through. But as the education is reviewed, as the applicant is cleared to sit for the exam, as additional information is provided and the background review process happens, the license issuance, all of those will turn, well, now I can't recall at the moment if it gives a check mark or, it'll give an updated status depending on where that application is. Right now we have an application tracker, but it exists outside of the online system. So this is a real, we're very jazzed about the marrying up of what's currently displayed outside of the system and what will be available inside the system. So yeah, this is another example of going in and looking at the application once it's been submitted. It's by going to My Records. That's it for the licensing. Any questions about that so far before Mike takes over? Yeah.
Good afternoon. We've already kind of walked through the registration process. It's necessary for you to set up an account, just like it was for a license holder. So we have that contact information for the complainant. So you would create an account, you land here. Next thing you would do, you click the complaints tab. Clicking there, I already have an account. I'm testing a lot, so it would represent if you have multiple complaints, it would have what's going on back down there. If not, then you just click there or enter a complaint. And go to the same landing page in regards to just doing the additional certification box. Like Denise said, we're not quite there with the language. Next box you land here where the drop down for the TREC complaints. You do the drop down and then you select the TREC complaint. And this is a process where you can either select from your account and add the information you already put on when you did your registration, or maybe you want to add more additional or new contact. And so you would click add new, and everyone you need to add your phone number, your primary phone number, email address, and your first and last name.
What if it's a consumer?
This is the same thing.
They have to have a login and do it that way as well?
Yes. Otherwise, we cannot contact them or communicate with them in any means. So.
But on TLBC, whatever, they've had online complaints for a while, right? But they don't have to go through this whole thing.
Well, they're actually going to do login registration as well.
Just don't know that consumers are going to do all this.
Well, it's just an avenue to report.
They do it now, they just do it on paper.
Yeah, but
Yeah.
I'm just saying, they already think the process is tedious. Are they going to do all of this? Are we going to lose complaints because of this? Can they still turn it in paper?
They can still turn it in paper, but we put it in a digital format and we'll be communicating with them the same exact.
So the way in which it's different from today is one additional step, which is to create an account.
Yeah.
Which is, none of us love that.
I
But
can
it's
tell you
what
that a
we
lot of people have problems with their PDF forms because it's difficult to format it. And additionally, what I'll show in a minute, uploading documents will be very, very user-friendly for the people because a lot of times they'll have that on their phone or their computer, and them taking like screenshots and doing a lot of other crazy things. It does make it difficult for a person to submit some of those things. So.
Yeah, so
Well, less clunky, no
removing-
attachments.
You're not removing any avenues of complaint initiation. You're just adding another one.
Yes.
Yeah. Okay.
Yeah, if someone writes a letter and they sign it and they meet the requirements, we're legally required to put that in and, communicate with them as necessary.
Not to mention the TREC initiated complaints.
Correct. So when you click continue after you may want to add your additional information. This will pop up, so we'll have your contact information. If you want to add a mailing address, it will have it at the bottom. Then you click on continue for the next thing. This is where you look up the license holder. We have two avenues. We have the lookup, which would actually look into the database And you can either, if you know what license type they have, you can search by that, and then search by their name, or search by their license number if you do have that. The second part, which is there for either unlicensed individuals, which wouldn't be able to look up on in our license database. Occasionally, you don't know exactly who the person is, or maybe they have just a business name or something like that. So they'd be able to add any of that information under the other respondents, and then we can go and look up and figure out who they're trying to file a complaint against.
Does it have any additional filters? John Smith, Midland, Texas. There's John Smiths in every community.
Yeah, that happens now. So yeah, when they add an individual, they'll get like some of the basic information of what they have. So they may have to figure that out. If they're wrong, then we'll reach out to them and clarify the situation. So
Yeah, I mean,
that
presumably
happens
when
now, like people will fill out the same name and maybe they'll be looking up the person, say in Houston, and like, yeah, it's a John Smith. They're not exactly which one it is. And we've had it where they picked the wrong person. We would open a complaint like, oh no, that's me, not me. So we'd go back to that complaint and say, hey, do you have any more information about this person so we can match it properly to the proper license person.
But the system won't have any additional filters for that kind of matching.
it would give you the brokerage, the associated brokerage. So
Well, you can look at that stuff on the website. Yeah.
So it's in two different places, you're saying. They have to go to the website to look up their license and then come back here and find the license number.
Or they can search by name, or, there's different ways for them to search.
They basically just plug in the information that they have.
Mhm.
And if they're wrong, we'll figure it out.
Yeah, and I mean, it's name and organization.
Mike, so when you do a lookup, you're not gonna get the name and the brokerage affiliated with them? Or just the name and the license number?
We just do the name and license
In this,
in this part.
when you're going to our website to look up a person, you get different, like outside of the complaint process. That's a different license lookup.
Unless you click on their name, you don't.
What do you mean? Well, I'm just
You go to
saying that
license.
this is separate from the license.
But if you go to the license search on TREC.texas.gov, it's just name, license number, county.
County, yeah, it's not much info.
Yeah.
I mean,
For now.
it's what's limited to what we can provide to the PIA.
Right, but then that's gonna,
Yeah,
we've got legislative implementation on the
you
business.
can't-
contact info coming,
Well,
but that's still separate.
the brokerage, affiliated brokerage is public information, right?
Yes.
well, they're sponsored.
If,
Why would we not include the license number, the licensee and the brokerage affiliated with it? So that you can at least,
Well, one of the reasons why is if I were to look up one of Mark's agents.
there's multiple brokerages associated.
Well,
There may
even
be.
then, it doesn't come up as Better Homes and Gardens Real Estate Gary Green. It comes up as GH3. If you look up somebody on mine, it doesn't come up as the name of my brokerage that we do business as. It comes up as our legal entity.
I see what you're saying.
And so it
I
wouldn't
see
show
what
up
you're
that, and that legal entity is what has the license.
In my experience, a lot of people know who they're competing against. So, example of double up on names, it's not that common. And we can do a lot of searching in the back office to make sure. But think about it, we're gonna get the documents as well associated with this and their explanation. So if the things don't match up, then we're gonna be like, all right, these two don't match
All I'm
up.
saying, that's a pretty traumatic experience from a responsible agent and broker to be called by TREC and said, hey, there's a complaint against you, and then
But we may not get to that point because we'll be looking at the information before we even.
hopefully.
So, yeah.
That's true.
Since this is brand new, yeah, there's gonna be issues, and thankfully our partners with Excel have been willing to work with us on making changes and stuff, so. All right, so after this, we get this, it would be the professional that you added. Some of the information will be added later on, it's just not in the system right now. This will give you the option for, have witnesses you wanna add. We kept it for minimum requirements that they at least need someone's name and how they relate to the complaint. So based on this last category here, information about the transaction. Often you may not know the phone number or email or vice versa. So we didn't want to make those things mandatory because it would just, slow down the complaint process. So. After that, if you don't have one, you can click continue. These are the standard questions that we already asked. We did add an additional question dealing, they need to talk about where maybe the location of the property or the activity was occurred. And this is just for us to better streamline a complaint, because we regionalize our complaints and shift them and filter them to certain teams. And sometimes it's a little difficult upfront for the staff that takes the intake to figure that out. So we're hoping that it'll be an extra tool for them to utilize. The second part would be the complaint details. They can write lots of characters. It looks like a small box, but it goes on and on and on and on and on. So that would be where you would add all your allegations. After that, you can continue. This is where I'm really excited about this part is you get to add any kind of documents you want, videos, you upload it, you can title it on a certain type. There's even an option to, and when you're adding the document, add a further description of what the thing you're adding relates to your case as well. So that'll be all additional information that we will receive that will be helpful down the road.
Like on the previous page, if they click yes to advertising, does it automatically go to advertising compliance?
We'll audit it internally and see it, and then we'll be able to route it that way. So, yeah. So after that, we have statutory requirements to have some certification. And when you do electronic signatures, you need to type in your name to acknowledge that you're doing an electronic signature. So this replaces the actual, wet pen type of signature situation, which I can tell you probably 10% of our complaints we have to send back because people have difficulty signing the PDF form or don't sign it all together. This will, if you go this method, we'll eliminate that altogether. We'll be able to jump on those complaints immediately. So after you go through that, there's just an additional certification notice, and automatically you'll get your complaint number. Right now, we have to process it, input it into our system, and then we will give the information, or give the complaint number. They will get an email simultaneously informing that we have received your complaint and give them, what's going to happen next. I think the next slide has the email. So this is a little bit of it. I couldn't be able to encapsulate it all, but goes through the process, gives some information of what maybe they need to do, and then they'll get additional information. They'll get an additional notification either if we don't have jurisdiction. They'll obviously receive notification they don't get jurisdiction. We sent it out for investigation. They'll get a notification for that part, and it would say additional stuff, what's going to happen, and basically they'll periodically get notifications throughout the whole process. Additionally, they can log into their account and do similar to what Denise showed you, where you can see the steps on there. They can go to their actual complaint into their account and see where it is in the process as well. Now, we can't give it sometimes some specific detail of the steps just due to confidentiality. But at the very minimum, they'll see that it's pending, resolution, or if there are some steps that we can disclose, then those would be the situations where that would be shown there. So that's it.
Okay.
Mike, how about self-reporting? Do you have an avenue for an agent to self-report?
Like file a complaint against
They
themselves?
file a complaint, it happens.
So you don't, let's say I was convicted of a felony.
Oh, so when we receive an email saying for the 30-day things, it's just a TREC initiated complaint. We just use the email or whatever it is, and we just start a TREC staff initiated complaint right then and there. It's similar. It's just how we handle it now.
But a self-reporting would have to come from the licensee, right?
Correct.
So they'd send a letter, or
Sometimes it was criminal stuff. Sometimes their attorney's good enough
Yeah,
to send a letter.
through their attorney, or
Yes.
a personal letter from them.
Mhm.
I guess my question is, you don't have an avenue for somebody to self-report within this new system. Something like that.
I mean, theoretically, they could file a complaint against themselves.
They can file against, they can file a complaint against themselves.
Yeah,
That sounds
it's
like
not
That
a,
process has not
Well,
changed.
it's not a
honestly,
complaint.
okay, so,
It's not a complaint,
no, but
not a
You just have
complaint.
to send an email, he says.
It's a reporting.
it's never, it's, if they're gonna report, they just send an email into enforcement.
They usually call or, and then
Yeah.
they're directed to send it in writing and they email it to us.
Mhm.
And then we do a self-initiated or staff-initiated complaint. So.
So to answer your question. No? So are you wanting to know whether or not there's a mechanism to do that in this new system?
My question is, why would there be?
would
Why
not.
would?
Why wouldn't there be?
Why wouldn't there be? Okay. We can look into it. I think we just.
You'd have to have a new complaint workflow configuration.
Okay.
Version 2.0.
Huh?
2.0.
Version 2.0.
So you're just talking about, so it's in the database and it's
Yeah.
not just lost as a.
If you're
an
tracking-
email. Yeah,
If you're tracking applications, dues, everything,
yeah.
I mean, we're paying, pardon my French, a shitload of money for this thing. And
Well, I
I
mean,
think that's a basic,
we're trying to adapt to what we have now to this and see how it goes. And, you know, if there's desire and need from the commission to add additional avenues for people to file complaints against themselves, then that's
No,
something that we can do.
I think that would be a desire on management's part to
Yeah.
have that. I mean, I'm just saying.
I just worry.
Keep everything in one place.
Yeah,
Yeah.
if you give an option to do that, like on that drop down there, I've worried consumers will go through that wrong process as well. I mean, it's just something we're gonna have to look at. So,
Well, you program it so that a public person would, a licensee would have a different menu item than a.
I'm filing report, blah, blah, blah.
Yeah,
It wouldn't be under the complaints tab.
No.
It would have to be under the license.
it'd have to be something, it's not a licensee will not complain against himself. It's not a,
No, no.
it's not a complaint, it's a
It's- yeah.
self-reporting.
Where they had the 3 tabs up at the top.
It
where
would be
was
one of them.
Licenses, home licenses, complaints.
Self-reported
It would
event.
have to be under the license tab,
Even-
not the complaint.
Yeah, even on the website where it says they need a report or whatever, they can click it and it goes to the link where they need to be.
It's a good question.
I'm just saying, suggestion.
Anything else we want to talk about there?
Can we talk about the Hawaii retreat?
Okay, good job, Denise and Mike.
Well, it is in Hawaii next
Is it?
Okay.
Okay, so
Thanks, Mike.
you want to move on to the next one?
Yes.
Okay, the next one is discussion regarding a legislative session. Summer.
So, good afternoon. Here I am in my career relations position. So, we're in a special session. There's not really anything happening during this session, period. But in terms of what's on the list of items, there's nothing that would affect the commission or how we operate. So we're listening out because I know there's at least one thing that's of interest to real estate license holders, but as far as we're concerned, there's nothing that we would need to do for it. So with regular session though, there was a good set of bills that we were following that passed. And I'm just going to highlight a couple of those bills and talk about how we're implementing that. And a lot of that's come up along the way so far today, so it might be a little repetitive. Hopefully seeing how the realm portal works will kind of help you to visualize how some of this might look for folks as we walk through. So the first one I'll mention is SB 711. This is the bill that requires condo associations to upload their management certificates to hoa.texas.gov. This is exactly like what property owners associations do now. It just extends to condo owners associations. So advocating with our web developers to update hoa.texas.gov so it's ready for September 1st when this is effective. Mostly it's just to make it clearer for users whether they are an association needing to upload documents or someone who's looking for the documents to be able to discern what's a condo association versus a property owners association. And just to note, homeowners association is kind of an umbrella term for both of them, but each one has its own chapter that kind of governs. So we also added some language like that to tell people where this is coming from. Do y'all have any questions about the condo bill? Okay, great. A lot of condo associations have already uploaded documents too, so it'll be interesting to see, what comes through. I do want to note that this doesn't change our regulatory authority in any way. It's exactly the same as it was, and that we do not regulate HOAs. It's merely we're the conduit to get the information out to the public, and then they can pursue things civilly if they don't see what needs to be up there. All right, so the next one, we had some rule changes earlier today related to, it's HB 5629, and it's the military service member, spouse, and veteran bill. So historically, it's been difficult to do reciprocity under current state law for military because the law says substantially equivalent. And there are no states that have substantially equivalent license requirements. So what we have done is there's a federal law that most military folks use to get their license with us. This new bill, effective September 1st, removes that substantially equivalent language. It also adds veterans. So those are kind of the key differences for the state level change. So we are in the realm portal, Denise actually showed it. There are questions, it's kind of like a skip logic sort of thing. So based on how you respond to these questions we'll have, it'll take you down the path for which type of license you're applying for. And this is important because we're also required by this bill to report on any complaints and their disposition for people who are licensed under the state law. So and speaking about this in implementation, and Abby can speak to it better, we really pulled this one apart, and it still seems like most people will have a better time going the federal route than the new Texas law route. But again, a veteran might be able to do it where they couldn't before. So those complaint reports go out quarterly. We have to put them on our website. We cannot say specific information because that's confidential, but we'll have tags and things in the back end so that we're able to identify who's who and just anything else we can think of, because my suspicion is that the legislature may ask us for that kind of data in the future. I think they have an interest in it. Does anyone have questions about the military bill? Wonderful. All right, the last one I'll cover is one we've been talking about all day, SB 1968, our housekeeping bill. It is effective January 1st, 2026. So broker responsibility is required, the course for all brokers beginning January 1st, 2026. This is regardless of whether you intend to sponsor agents. Delegated supervisors are still required to take this course. It hasn't changed anything. Brokers will be required to take it upon renewal. So again, it doesn't matter if you sponsor agents, you're going to take it. The other piece, another piece of it is that TREC can adjust qualifying education requirements by rule instead of statute. And this includes an initial sales agent license. So Director Jennifer Wheeler is going to talk a little bit more about that later, about what that means practically and what we may be looking to do. But overall, the takeaway is it'll be much easier for us to change things. We won't have to wait until a legislative session to go make requests and changes. All right, the next one is kind of two-pronged related to associated brokers. So we got the authority to display associated broker affiliations on our website, which means we need to be able to collect that, which means we need to configure that within the Realm portal. So we're working on how to do that. It is a requirement of the associated broker to identify who they associate with, not of the other broker. So the responsibility falls on the associated broker, although the broker will be able to come in and say, yes, that's true. So let's say I'm an associated broker to Abby. I list that in my profile dashboard, wherever, and then Abby has an opportunity to say, yes, that's accurate. Then the next step of that is we'll be able to pull that data onto our website. So when you're doing license holder searches, you should be able to see my connection with Abby and Abby's connection with me, whether you're on my profile or her profile. Do y'all have any questions about that element?
Both on the agent side and like the sponsoring broker side. I'm sure they PNP around.
Yeah, that's a great point. There's also been changes to TREC rules you saw today about who will receive notice of an associated broker's complaint. So this was an initiative that y'all had in the Broker Responsibility Advisory Committee. Basically, we needed to seek the authority to be able to say that a complaint's been filed against me, Abby, just so you know. The letter, though, it won't go into great detail because, again, that information is confidential. There are a couple things behind why someone may be subject to a complaint. That's not just, I filed a complaint against you. There are also background history issues. So the letter will essentially say, Summer's got this complaint. Abby, you should reach out to Summer if you want more information about the complaint and what happens to it. So we aren't given any authority to provide any additional information beyond that. So it's a notification requirement. Any questions on that item? Okay.
That's great.
Then another piece of this bill is obtaining license holders' business contact information for public display. So what we're looking at in the Realm portal, there's something called an amendment where we want it to say something very obvious, hit you in the face with, this is where you're going to enter your publicly online displayed business contact information. And so this is required of all license holders as of January 1st. It's separate, collected separately from application because that's required by law. Also, people will be able to use a PO box for that contact information, and that's different from when you are applying, or the lawyers will correct me, but we have to have like a service address. So this is different from that. This really is, we're collecting this to show it to you, and that's kind of the remedy that we sought to get that authority when SB 510 passed last session. We weren't asking whether somebody was giving us their personal information or their business contact information. So that's why all of it just had to come down because we're not supposed to be giving out personal information. And then just, I think of interest to you guys, the non-representation status, written agreements, and the elimination of sub-agency also in this bill. So you heard earlier today that the Broker Lawyer Committee has talked about a lot of this stuff. And right now they've decided that they're not going to pursue creating any forms, just kind of see how things go when it comes to the non-representation status. We're also updating the IABS because of these changes. And so rulemaking with that. This information is in the new legal update course, which I'm sure you all read with multiple appointments. And this is really primarily just the communications implementation piece that we'll continue to put out there. I'm sure we'll have a lot of questions and interest about what this means for folks. So, and that's pretty much it. Any questions?
Abby, there was a change to the Open Meetings Act. Are you guys on top of that? Okay. There's the 72-hour rule. It's House Bill 1522, I think. The 72-hour is gone. So filing for a Monday meeting would have to be on Tuesday at no later than 5 p.m.
Yeah, there's actually a couple bills that touch on Open Meetings Act. And so we've got a whole really cool spreadsheet that Summer put together that tracks all of this legislation.
Yeah, so this isn't all we're doing. There's much more.
That affects more you guys than anything else.
So will the business information then be published to the high value data sets that are going out there?
Well, we're having those conversations.
It'll definitely be on the individual.
I couldn't hear the question, Danny. What was the question?
I asked if when they put in their business information, if that'll show up on the high value data sets that everybody and their grandma uses to recruit new licensees, or used to recruit new licensees, but doesn't anymore.
Well, that is a discussion that's currently happening, certainly on the individual.
I asked that on behalf of all my managers.
Yeah. It's also something that we get a lot of complaints. I mean, we used to get a lot of complaints about. And I think it was the reason maybe it wasn't the sole reason, but it was a driving factor into the original SB 510. Was this idea that agencies are, I mean, people would say you're selling my data. We're obviously not selling it, but
Give it out freely.
yeah. And so, I mean, that is a discussion point and something to weigh in on from the legislative, as part of the legislative update.
It'll either be in the high value data set or it will be available to the public information.
That's a great answer. Yes.
So we'll be able to get it.
But it won't just be up.
HAR, we've talked about this before. HAR has also talked about getting a last modified timestamp on the TREC.txt file that they get every night, so they know what's been updated, so they can update their systems faster. And I know that they've gone back and forth in the past because I was on those emails, but I don't know that it's for sure been implemented. You probably know more.
It has not been implemented. They have heard the.
Okay.
It'll need to be something I go back and look at.
Okay.
Okay,
All right, thank you.
thank you. Temporary suspensions.
That's me again. Okay, so our last item for workshop is a discussion about temporary suspensions. This is actually something, and I'll stand over here. In my back. This is actually something that Enforcement Committee heard this presentation and then requested that this be brought to you all as a workshop topic. I'll kind of go through the background as we go. But this is just something that originated from a conversation at the May Commission meeting. And it was tied to a contested case that was heard at that time. And there were some questions raised about the timeline of that. Are there other options that we could have employed in looking at that case? And so that's where this comes from. Yes. Yes. Okay. So, temporary suspensions background. So we actually have two provisions in statute. One is in the Real Estate License Act that applies to brokers, agents. The other is in the inspector chapter 1102. So 1101.662 and 1102.408. And under those provisions, it says that the chair of the commission appoints a disciplinary panel of 3 commission members to determine whether a person's license should be temporarily suspended. So historically, this has been the Enforcement Committee that does this. This is a really important part of the statute and kind of the question or the framework with which we have to look at these issues. And that is, if the panel determines that the person's continued practice would constitute a continuing threat to the public welfare, then the person's license has to be temporarily suspended. So that's the level. Okay, so continuing on with a little bit of background. So to temporarily suspend without notice or hearing, kind of like you think of it similar to like an injunction. You might be familiar with that term. To do it without notice or hearing, the commission must, 1, institute a contested case hearing at the same time as the temporary suspension. So that's the process we all just went through today. And that hearing has to be held as soon as possible. That's if you do this without notice or hearing.
So it automatically bypasses normal enforcement and goes straight to
Well, no, it would still go through that process. It's just like a simultaneous path. So you know how like on
It's status. It's temporarily suspended and then the
and it goes
process.
through the normal
And then you go-
process, but just on an expedited.
It's just a license status.
Yes, and.
Gotcha.
Yes, sorry, I'm not doing a good job.
No, you're doing great.
Okay, so one of the things that we discovered when we're looking into this issue is that there are statutes actually throughout the occupational licensing statutes that are very similar. So sort of sometimes really just look like a cut and paste. So the language was nearly identical. So like engineers, appraisals, appraisal management company, very similar, if not identical language. The other thing we found is that health professional chapters, so doctors, dentists, nurses, also have this authority pretty routinely. And one thing that I'll come back to at the end, one of the kind of commonalities that we saw is that most of these agencies have rules tied to this process. We do not currently, but most of the agencies do actually have rules that can kind of provide some further guidance. So one of the things we did in kind of investigating this topic is, how has this been used in the past? How are other agencies using this? And so, again, coming back to that kind of framing question, does a license holder's continued practice constitute a continuing threat? Another way to think about that is, how does use of the license connect with the need to temporarily suspend? So when did we last use it? We last used this provision in 2018. In that situation, the license holder was actually the subject of more than 40 complaints, and they were all basically the same type of complaint. Some of you may even be familiar with this particular respondent, but the complaints alleged in all of kind of across the board, she failed to account for remit trust money that she collected as a property manager on behalf of property owners. And she also that she was acting without a sponsoring broker. So based on kind of the number of complaints that were all alleging very similar facts, repeated practices, in the motion for the temporary suspension, our staff said, this indicated a disregard or inability to abide by applicable law or commission rules, just because of the repeated similar nature, the same thing over and over again. So the enforcement committee at the time determined that magic language would constitute a continuing threat to public welfare, because she would likely continue to misappropriate money. She had done it at least 40 times. So her license was temporarily suspended. And then ultimately, when it went through the kind of the remainder of that process, through that contested case process, the license was revoked and she was assessed a $122,000 administrative penalty. So that was the last time TREC used it. The board, the Texas Appraiser Licensing Certification Board, has as I mentioned, a very similar statute. And they last used this in 2019, kind of similar facts. There was an appraiser who was at least 5 times sort of routinely accepting payment from clients for appraisals, never delivering the report, never issuing any refunds. So an investigator in that case said that it was one of the investigator's top high-risk cases, because this appraiser continued to misrepresent that they would do the work, never did it, wouldn't give money back.
Oh my gosh.
So just a few other situations we found going a bit further back. So in 2014, there was a very similar case with a property management scam, really targeting military personnel, where there were over 25 complaints filed. The complaints were similar in nature. And then there was actually, when we used to regulate RSCs, residential service companies, there were multiple complaints filed against an RSC that was essentially insolvent. They continued to sell contracts to consumers, but they were insolvent. They had ceased paying out claims on existing contracts. We did actually kind of informally poll other agencies just to see, where they're using this, when they're using this, how frequently. The feedback we got was that it's pretty rare. It's used in situations sort of like we've outlined, these sort of one-off emergency situations, or where there's a sort of repeated conduct happening over and over again. I'll talk about in a moment how sort of the medical professionals are a little bit different. Their statutory language is a little bit different, so they use it in different contexts. One thing to know, when we ask them, do you use this in sort of a general criminal history situation where there's criminal history that's not necessarily tied to the practice of the license, like you saw in maybe the other cases we just went through. They said that they don't use it in that instance. So next slide. Okay. So this is sort of what I was alluding to a little bit. So the commission cannot temporarily suspend license holders based on arrest. That's because of the language in Chapter 53. Specifically in Chapter 53, arrests or charges only cannot be used as grounds to suspend a license. That includes temporary suspension. But what was interesting is some boards, like the medical board or the pharmacy board, actually do have separate statutory authority to take action based on arrest. We don't have that authority, but those agencies do. And it's sort of like in instances where someone might be accused of improperly issuing prescriptions for a narcotic or something like that. We saw it a lot with like boundary violations, some assault essentially of a patient. So those were some instances where that was permitted under those laws, but it's a little different from ours. Okay, so this brings us to, that's the kind of all the background and the framing. This brought us to the contested case that was heard by the commission during the May commission meeting. So in that case, a sales agent pled guilty to federal felony offenses of conspiracy to commit wire fraud and of filing a false tax return related to the use of approximately $4 million in donations from 2 charities. The agent was ultimately sentenced to 5 years probation in order to pay an assessment, $100,000 fine, and a big chunk of restitution, over $1 million. The commission at the May meeting revoked this individual's license. So one of the things that the enforcement committee asked us to put together is sort of a timeline just to see how this all worked out, and then use that to kind of analyze it with the temporary suspension process to see if this would work in this situation. One thing that this was really interesting in shedding a light on is sort of the differences between the federal process and the state process in some ways. But we'll start here with the first item there. August 16, 2022, respondent notifies us that, that this person is pled guilty via the agreement in federal court. January 17th, 2024, commission staff is notified by the attorney for the respondent who's about to be sentenced. So staff preemptively opens a case against the respondent. February 23rd, 2024, respondent is sentenced in federal court to 5 years probation in order to pay fines, assessments, and restitutions. So under federal rules of civil procedure, a plea is not considered final until after sentencing. And what was interesting to note here is the federal judge entered 2 judgments, one on January 29th, 2024, another on February 23rd, 2024. That later one modified the sentencing, removing prison time that was initially ordered. February 27th of 2024, we sent the respondent an NOAB, a notice of alleged violation. The respondent requested a hearing at that point. On March 5th, TREC sent respondent a notice of hearing, and then later on in July of that same year, at respondent's request, SOA reset the hearing for November 13th, so the respondent asked that to be rescheduled. July 23rd, just to note, the respondent's license went inactive. And then we are to that November date where the SOA hearing was held. The PFD was issued in January of the next year. And due to the time period, there's a period after a PFD is issued where you have an opportunity, the parties have an opportunity to file exceptions or essentially challenges to the PFD. That meant ultimately that the first time the case could be heard by the commission was at the May 5th, 2021. So, one of the questions that we were asked, was this a situation where a person's continued practice would constitute a continuing threat to the public welfare? Staff's position is that it was not one of those situations. We would not be able to demonstrate, or we would have difficulty demonstrating that their continued practice would constitute a continuing threat. When we talk about continued practice, it's, demonstrated again, a lot of times by these frequent complaints, same nature, same facts over and over again. That wasn't the case here. So that's staff perspective. I'm going to turn it over to you all in just a moment. But I want to go to the next slide, which is our last slide of potential recommendations for you all to consider. So again, as I mentioned, there's many licensing agencies, including the board, that have rules that provide further guidance on the temporary suspension procedures. That's the board rule, 157.25. As I mentioned, we don't have a rule right now. the commission could consider adopting a rule to provide further guidance or process to staff, if you think that would help kind of align things. And again, that might assist staff in the identification of these situations where authority is appropriate.
I thought when we discussed rule in that enforcement committee, you said it pretty much isn't going to change anything because you're just, the way you interpret statute is this, and the rule would just explain it better.
Well, so I think if there's a disconnect between, what staff understands the law to be and what the commission, for instance, understands the law to be, that won't solve that problem. But what it would do is provide more process or more guidance on how to use it. And when you do use it, here's the process you have to follow.
Yeah.
So I think it solves one issue, but maybe not another issue, if that makes sense.
Did you talk to TLCB and savings and mortgage banking?
I've talked to TALDB.
Because they use their temporary suspensions differently.
TDSML does.
No. TLDR.
Oh, TDLR. Yeah, I certainly can.
We did talk to them a little bit. They responded to kind of our general ask of like, how do you use your temporary suspension? The examples they provided to us were almost entirely related to human trafficking and within the licensed type of like massage therapy. And so that is sort of connected to the practice. They're using the massage therapy kind of practice as a way to traffic humans. And so they use that pretty liberally there. But that's the guidance we got from them. They also agree that it is not appropriate to use the temporary suspension tool for more general criminal history unrelated to the practice. And I don't mean unrelated in how we treat it in order to get a license, but in the activities related to the criminal offense being the same activities that are related to, in this instance, real estate.
So how is a sex offender not related? Because we have 3 licenses now.
Well, because there's not, I mean, this seems kind of like, I don't mean this, like that's not practicing real estate.
It's walking into a house. It is.
Well,
what if your child was in there? What if was in there? And that sex offender walked in your door?
Well, I'm not meaning to personalize this.
I kind of understand where you're coming from.
Yeah.
But if you go back to this one slide where it talks about May 5th, right? And so right there.
Yeah.
And your question there at the very bottom says, was this a situation where a person's continued practice would constitute a continuing threat to the public welfare? Did we not argue that before he saw a judge to get them to revoke his claim?
Not that exact issue. What's kind of interesting is when you look at chapter 53, it actually uses a similar phrase. And I found this kind of interesting. One of the phrases it used when we're looking at whether to determine whether a deferred adjudication is a conviction, one of the things that has to be established is that this person may pose a continuing threat to public safety.
Mm-hmm.
Well, may pose is different from continued practice would constitute. So I understand that, it's a similar argument, but the standard is much higher, which I think makes sense. You want a higher standard if you're going to temporarily suspend, especially without notice or hearing. But that's why the arguments can be somewhat similar, but
the same
standard, yeah.
The same standard that we're using to revoke him would have been the same standard that we would apply to deny him a license to practice in the first place.
But our bar is higher if you're going to do it without due process.
Right.
Well, that's my point, is that we have the ability to temporarily suspend them because he has violated a fiduciary, although not directly related with real estate or practicing real estate. That's the problem. The problem.
I thought the minute he pled guilty, we could revoke our statute.
It's the continued threat of practicing real estate.
But we could have revoked per the other word used to
But
suspend.
that,
No,
that has
no.
that has a different standard though. So, that goes through that whole, chapter 53 process. You look
This
at
is-
all those
This is
factors.
temporary suspension.
No, right, I'm just saying, because he pled guilty, our statute reads that you can revoke. When
Oh,
you plead.
and you're talking about timing, like the
Yes.
minute that
Yeah.
happened. And so
Yes.
do you want to talk about?
That's the federal part. Tammy.
Yeah, that's the federal part that gets
This
it's
is
fun.
like a weird one.
Yes.
Yeah, so that is the federal part. That's just the normal sort of process of when we can take action. But this, we really have to, the only thing we can really look at for a temporary suspension is that question. And again, because, we're being asked, we're essentially, stopping someone from being able to use their license, make a living without all the due process that's normally attached. That's why that standard is a little bit higher.
So my question is, do we have an internal process for it? Like when y'all get a complaint and you look at it and it's 53 lease frauds in a complaint, is there a trigger in your process that says, hey, maybe this needs to go before enforcement for temporary suspension?
So essentially, this happens so rarely that when it's happening, it's very obvious. And so when anything, like you have like multiple complaints that look similar, then that comes to us, hey, us meaning like general counsel and executive director, this looks like something we need that is a potential temporary enforcement action, but it's just so rare. The question is, do you want to put meat on the bones of that fairly informal process to ensure for y'all's kind of comfort to say, okay, now we know exactly what that's going to look like because it's
I look at the case from today, for example,
Yeah, I would like to.
where you had somebody participating in lease fraud. And even after notice, continued to do so. I think we owe the consumers.
Yeah.
Yeah,
Yeah,
stop.
that'd be
I
good.
want to add something to that. So that woman, so the complaint, she got her license in May 2023. After that, she did 23. In 2023, she did 23 transactions. 2024, when she was turned in, she did 58. In 2025, she's done 52 already. But since 3/11, when she was told that this was going, or she was done, she's done 37. And since
That shouldn't happen.
3/18, when y'all finally said, okay, whatever, stop, she had done more than that, 38, I believe, or 39, and then she has 2 pending now.
two pending
Transaction.
transactions.
So when was
Got
the first complaint received? What date?
2024, they said February 2024.
February 2024.
And then it wasn't adjudicated until when?
Today.
3/11 is when they said that she was getting her license revoked. And then 3/18, I guess, is when they noticed her.
So if you take
Still,
that, yeah, and then you got that, so the
Mhm.
procedure.
But 3/11 is when SOA made their report.
And then it
Not-
became
She's
final
done, she's
today,
done,
essentially.
first of all, we didn't hear it in the May meeting, but she's done 37 since 3/11, 37 leases,
So February of 2024.
not including the 2 pending.
We knew that there were several issues related to her false, using that crystal, what was the name of the fake,
Was using a property.
Landlord,
yeah,
fake landlord,
Yeah,
Second chance.
second chance.
second chance. The irony.
Yeah, there's some irony.
She's still advertising all over the place.
So I think that might be a reason why having rules in place that say these types of things
I think
trigger.
so.
I mean, I think that could help y'all influence what this looks like.
To her point, what would be the triggering mechanism in this case? Like, what would Mike look for?
I think we would have to spend some time drafting some rules to see how to capture them all. I mean, one of the things would be like the volume of complaints. In this case, I don't think we've gotten a high volume of complaints, so it would need to be
The minute you see
An
fraud, I think it
indication.
needs to go.
I mean, I think there's a I think there's validity to that in that, especially over the last couple of years, as we've seen these lease scams happening more and more often. Like, you know, where there's smoke, there's fire.
So
And we need to put the fire out.
I think we could certainly look at that, to your point, if there's, fraud or some circumstance which the commission deems particularly egregious. I mean, we could certainly look at all that.
I'd rather err on the caution side and have the
Sure.
committee look at it and say,
Yeah.
nothing to see, let it go through the normal process, right?
Yeah.
Then not, and then 3 years later, because it falls under federal court rules,
And I agree.
shoot,
Yeah, look at all.
3 years and
We could have.
I would have rather
Helped.
take any of these ones that are halfway on the fence than for a committee to look
Yeah,
at
agreed.
it. Like commissioners who are in the business all the time who see it. Yeah, I'd rather that
Yeah.
happen than, I don't want a sex offender walking into somebody's house. That's,
or you can't, sex offenders.
I'm gonna separate those two because there are a lot of people walking around that are registered sex offenders that are married to the person that they raped.
Correct.
but I'm
Keep
just,
that in mind.
but I'm just saying, you don't want
But,
that. I mean, our job is to
dad
protect the
Filed
public.
a
Our
criminal
job,
complaint.
whatever they did, they're still on the sex offender list, and our job is to protect the public. Do they have the chance to reoffend by walking into your house? Yeah.
But we'll still run into that same issue of we need to be able to connect the license that can.
To the
be
active-
The time you walk into a house, you have the opportunity to reoffend. I mean, it's just a mental state.
But again, because of that, how that standard is worded, I think we would not be successful trying to argue that, in every situation, that's going to.
Why don't we
So,
start with seeing
I
if we
think-
can get something that
So let me pose this. I mean, those are the type of issues that we're gonna throw everything on the wall in the rulemaking process. This is what we consider the parameters, right? That we identify to suspend or not, recommend suspend or not, right? To even go into the process of a temporary restriction, right? But at this point, we don't have anything for Michael to say, okay. And a lot of these things don't get discovered until further on into the investigation that,
We can't
Yeah.
suspend someone until our investigation's done and we
Yeah.
know, and we're send the NOAV out and we're ready to roll. Because we have to set that thing at SOA as soon as possible. And they're gonna docket it. And if we're still waiting to interview people and gather evidence,
Not there.
we cannot, this is probably, we go back to due process. We cannot drag on the process for our benefit one way or another. We need to be ready because they can file for injunctive relief to get their license back because we weren't ready. So that's why, like, there may be a pause in there. They may be doing bad things. It's unfortunate. And I give you, these fraud cases, the more that we're getting into them, we are having discussions and you're probably gonna see stuff down the road. If the people don't capitulate and just give up their license or whatever, they're gonna go for a hearing, which in this case is rare. Most of our, all the frauders that we've had, they've either defaulted or they've done an agreed order to give up their license when the gig was up. So,
absent is
But-
over here, right?
yeah, but this one's, that may have been a good case for it. I'll admit that.
For the sake
Yeah.
of just clarifying, walk me through that process if you don't mind. So you receive complaint
Correct.
and then what happens between that and it, notice of alleged violation? And from a timeline standpoint, where a red flag could be raised in a place where you would be comfortable raising a red flag.
Let me clarify one thing that what we're talking about is what Mike said is we have a guilty plea in federal court
Yeah,
of something,
right.
right?
So-
And so at that point,
I'm thinking.
at that point, that's an easy one, right? That's low hanging fruit at that
Let's do
point.
more, yeah, the substantive cases,
Yeah, I'm talking about like the case today,
the rental
where we've
problem.
got somebody who's
Correct.
doing fraudulent rentals.
So it takes a lot of effort to get that information.
But I guess the question would be, let's say that she's done this 50 something odd
Mhm.
times, and we may not have 50 complaints, but it's clear she's
Correct.
doing this.
Yeah,
How many do we have
She's
to be able to
advertising all
prove
over.
up before we just say cease and desist? Let's go to SOA. If we get more information, cool, but if not, we've got enough here.
Yeah,
right?
It seems like in an
Unfortunately, that's part of the
investigation, if
investigative
we
process.
see
I don't know I just don't know what that looks like.
Yeah,
Time wise.
and it just, sometimes it just depends on the case in regards to
Okay.
collecting the information.
Well, we can work on rules.
Yeah.
Yeah.
I mean.
Yeah.
I like it.
I mean, we take obviously guidance from everyone here.
Yeah.
So if you want us, I mean, definitely be more aggressive on these things, and the more come up, it's obviously something that my team's been talking about, so.
Abby, you know, when we're talking about the difference between federal and state, had this been in a district court,
Mhm.
we wouldn't be here, right? Well, this wouldn't be an issue. I mean, it would have been adjudicated fairly quickly, right?
Well, I mean, it's kind of hard to say because I think in large part, there's an issue with, I think, just inherently the SOA process taking a longer time too. So I think, you know, in the May case, regardless of what time period we're talking about, even if we, you know, we're talking about the sort of the February 2024 time period, you're still looking at, you know, 15 months of, and again, not to say that this.
Well, we couldn't go to SOA until after the sentencing
Right.
anyways. That's what I'm saying.
That was the February 2024 date. So
Yeah.
even if you're looking at that, that's still a 15-month, you know, wait until you all take action. Now, again, I don't, for the reasons I went through, I don't think that this is the case for that, but I think it highlights there are sometimes long periods of time, just because of the nature of how quickly SOA can or cannot move. And so that's something I think is helpful for all of us to hear. And I think, again, I'll just say it again, I think a rule to provide some kind of bones or to
framework.
process would be helpful on our end.
So
Why
just
couldn't that
kick
be
to enforcement?
revoked when he pled guilty? When he pled guilty, why couldn't it be revoked?
Well, I mean, this gets into an issue
Same
that's
issue.
not tied to the temporary suspension issue.
Right, that's
Yes.
totally different, but why was?
Because it's not adjudicated until.
Yeah.
There's a
Our-
judgment. We
But our
did,
statute says pled guilty.
No.
But it's not.
Even though you plead, he's got an opportunity to appeal all the way to the end, to the sentencing. So it's open.
Yeah.
It's
So can
open.
we have a rule if you plead guilty, you can be temporary?
We'd have to change that by statute,
it'd have to be a statute.
statutory change. And that's the whole crux of it, is that it's not the end until it's the end.
Right.
Until the judge says, okay, whatever.
If you plead guilty to fraud or whatever else,
I
then we
would
should be
think,
able to temporarily suspend.
I would think so.
I mean,
agree
at the
with you.
end of the day, we all have to remember, we're here
I
to
don't disagree.
protect the public, not the licensee.
That's true. And, well, maybe that's a legislative item for TR to look at.
Yeah, we can certainly, you know, have these conversations, for, you know, future legislative.
All right, so as far as rulemaking, is that we could get to enforcement committee and they come back with something, or?
So that's something that you all are interested in, then yeah, I think what staff would do is we would come up with a draft, pitch it to enforcement committee first, have those discussions before it would be brought to you all at a meeting. So that might be a quick process, that might be a slower process. It'll just kind of depend on.
I'm for it.
Yeah.
I am too.
Do it.
Okay, well, this is helpful, thank you.
So there's nothing we could have done.
I know.
Not on this one. Or this case isn't a good one for temporary suspension.
Right.
Why
Which
was
makes sense to me.
Why wasn't today's case brought in May? Since it would happen in March?
I don't think it had
Because the-
completed the SOA
SOA.
process with exceptions and all that.
So there's a 30, I think it's 30 days, right, for exception.
Exceptions.
Well, it's 14, and then you have to receive confirmation back from the judge that they've basically disposed of the case and returned it back to our jurisdiction. So that could be at another
So
10 days. We try to speed it up as fast as possible, but we call the clerks, and that you don't want to be too much of an annoyance sometimes.
Mike likes these to come off of his list. He has every reason to try to get these because they're the older ones. So they're the ones that show up in his
Aging.
I can tell
Yeah,
you, we've
case
docketed
18
more
report.
cases this year, the only other top year we've done before was 2019. We've docketed more cases this year
Really
than the past, I guess, 5 years now.
interesting.
Next, I can tell you, this coming down the road, unless they get settled, we have a case every week in almost through October.
I mean, just out of curiosity more than anything, is there a thought process behind why that is now? Is it
Well,
increased volume of
I
complaints?
just like, so I think now that we've gotten quicker on our cases, we're getting a lot more substantive cases. So people are fighting the substantive related cases as well,
Gotcha.
where like before, like, do this
Here's my license.
stuff, it would be a year past or something like that, and they're less willing to fight it. Or maybe there's a civil action going on and their attorney's like, no, we can't settle now. Because if you agree to a punishment or something,
That
and
affects
that's
that.
gonna blow up our civil case. That's what we're hypothesizing. We don't know for sure.
Yeah, just curious.
Yeah.
Interesting.
Generally, on enforcement, even at the other board I served, we waited for all.
Yeah, the board probably has a deferred statute. They can defer all actions until civil ones are done.
Even civil, yeah, you have to wait, 'cause otherwise they're gonna take your ruling and use it in court against.
Yeah.
Sure. Definitely don't want that.
All right, so, request for potential future workshop agenda items.
We covered some of that in the
Yeah.
meeting, so we'll have
We got that, yeah.
annual
meeting.
meeting, the realm.
Got this again.
So unless there's anything else.
Okay.
to add.
All right.
Meeting
Well,
adjourned?
Anything else?